You're charged with the offense of driving while intoxicated with a child, 15, under 15. Did you understand?
Yes.
All right, that's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail. Announced for the record for the state.
Mariela Encinas for the state of Texas, Your Honor.
Defense.
Joseph Appel for the defense.
Are you Miss Baez?
Bass.
Bass. All right, is there one B or just?
One B, I mean, one
One
B,
A.
one S.
Okay. Counsel, have you received all the discovery in this case and did you review it with your client?
I believe I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Bass, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
You do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, Ms. Bass, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it?
Yes,
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of driving while intoxicated with a child, 15, under 15? Did you understand?
Yes.
All right, that's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against him?
I do so, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so.
Ms. Bass, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargaining page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargaining agreement, punishment is to be assessed at 180 days in the state jail facility. There's a $500 fine, no application for deferred adjudication. State recommends community supervision, and there's to be restitution to Carlos Tovar and ignition interlock for half the term. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it?
Yes.
Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only things that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
Next, I'm showing you outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 150 hours community service restitution, 1 year driver's license suspension, DWI intervention, and VIP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plea to count 1, paragraph A, B, and C?
Be guilty.
State any evidence support the defendant's plea?
Yes, Your Honor. State offers State Exhibit 1 and all attachments.
We've reviewed those, Your Honor, with the defense, with the defendant, Ms. Baz, and we have no objections.
All right, you may be excused.
Yeah.
Ms. Bass, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty in count 1, paragraph A, B, and C. And the court will find you guilty. Are you proceeding with sentencing?
With permission of the court, Your Honor, yes.
Anything you wish to say on behalf of your client?
If it pleases the court, Ms. Boz has readily accepted responsibility for her actions on that day, as not just evidenced by her plea of guilty, but this is the first setting that we're on. And she actually, as the court is aware, turned herself in yesterday due to a misunderstanding and miscommunication of her court date a few months back. But she wanted to take care of this as soon as possible, thereby also showing her admittance of guilt and her acceptance of the responsibility for her actions. With respect to Ms. Boz herself, she's been married for 6 years. They have 4 children, ages 15 now, just turned 15, 9, and twins that are 6. She is currently employed at Spring Hill Marriott, and she has been for almost a year in the housekeeping division. There she lives with her husband and her 4 children. Due to the certain financial limitations that she has, she is on Medicaid for the children and some financial assistance, mainly food stamps. And so we're going to respectfully request the court to not only follow the plea bargain, but when you do, Your Honor, to assess the minimum reporting fees, minimum supervisory fees, as well as follow the $500 fine. And since restitution may be involved, she did have insurance on the vehicle. If there's any restitution that's involved, that's important, we believe. And so if you could probate some of that fine as well. She does realize and recognize it is already low considering what it could be. With respect to that, Judge, we do ask you to follow the plea bargain.
All right, anything you wish to say, Ms. Bass?
I truly apologize for my actions. I know it wasn't right and I messed up and I'm trying to hold responsibility for what I've done. And if you just give me a chance, I really don't want to be out of my children's lives. Like, I know what matters and they're my priority. I should have known this 6 months ago, but there's no excuse. There's not. I really, really am sorry. Like, I made a mistake.
No, not a mistake. I always tell people a choice.
A choice. I made a wrong choice.
Yes. Because what I've discovered, and I always tell people this, my statistics professor will be upset with me because I haven't done a study, but based upon what I've seen, usually the person who's driving intoxicated, when they get in an accident, they're just fine. Usually it's their passengers who get killed. In this case, it could have been your children. Usually it's some grandmother who's just out trying to enjoy her golden years. I put myself in the golden years category because I'm in the twilight of my life. But usually that's who it is. Somebody who's just trying to enjoy their life. And I don't know why it is in San Antonio and other places. Guess what? If you're going to drink, just have a designated driver. I don't drink. I think alcohol doesn't taste good. That's why I don't drink. But I was always a designated driver for people. You know, because of that, I got free Sprite with lime from everybody because they're like, Stephanie's the designated driver. And I was fine with that. Have a designated driver. Or you know what? Take the VIA bus. I'm going to go drink. I'm taking the VIA bus. Or either drink at your house. There's no need to get behind the wheel because things can go badly pretty quickly. You understand?
Yes, I understand and you are correct.
Okay. All right. This is what I'm going to do. I'm going to sentence you to a $500 fine that will be probated, 180 days in the state jail facility, suspended and probated for 2 years, proof of employment within 15 days, no employment as a home health care provider with minors, restitution, if any, to Carlos Tovar. If for any reason the restitution appears that it's not what it should be, you can always approach the court. 150 hours of community service restitution. I'm going to require parenting classes. Once you complete the parenting classes, that will satisfy your 150 hours community service restitution. I'm going to want 90 sober meetings in 90 days, 1 year Texas driver's license suspension, DWI intervention, VIP, regular reporting by Zoom or in person. I'm going to want a TAP evaluation. If the TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. If it recommends intensive outpatient treatment, we're going to start with supportive outpatient treatment. I'm going to want ignition interlock for half the term. We'll do field visits one time for 2 months. If there are no issues with field visits, then probation, you can discontinue them if you think it's appropriate. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Thank you for dressing appropriately for court. And thank you. You were taken into custody yesterday. You were released and you still made it to court on time. I appreciate that. And thank you for your honesty.
Judge, we may need to go back over one more thing. It has to do with the vehicle. She doesn't have a vehicle.
All right. So if she does not have a vehicle, we're back on the record. You will need to provide an affidavit of non-driving. So that means that you cannot drive any vehicle. And probation, I want it checked to make sure that there are no vehicles at that home. And then if that is the case, then the court will order a mobile device. And probation, she can do whichever mobile device, which is the least expensive one.
I believe she's currently on Scram, Your Honor.
Okay.
And she's been riding the bus since she lacked the funds to get the vehicle out of the impound. And I do realize, and I've explained to her that if she does get a vehicle, then she's going to have to come back to the court or have admission and placed on that vehicle at that time. And that term has not expired yet.
Okay. All right. Thank you. The court is calling 2023 CR.
This courtroom proceeding before Judge Raquel West centers on a serious felony charge, driving while intoxicated with a child under the age of 15. The offense carries a potential sentence of up to 2 years in a state jail facility and a substantial fine, reflecting the heightened danger posed to minors. The defendant, Vanessa Bias, enters the courtroom having already accepted responsibility through a guilty plea. The plea deal outlines 180 days in state jail, suspended in favor of 2 years of community supervision, along with fines, restitution, treatment requirements, and an ignition interlock device. On its face, the agreement follows a familiar structure seen in DWI cases involving children. However, the emotional and moral weight of the case intensifies when Judge West addresses the real-world consequences of intoxicated driving. Bias explains that she is a married mother of 4, employed and reliant on limited financial assistance. When given the opportunity to speak, she becomes emotional, apologizing and acknowledging that her conduct was not a mistake, but a conscious choice. Judge West seizes on this admission. Drawing from years of courtroom experience, she delivers a sobering observation. In many drunk driving crashes, the driver survives, while passengers, often children or elderly victims, pay the price. The judge makes it clear that this case is not hypothetical. The risk was immediate and personal, and the potential victims were the defendant's own children. Despite the gravity of the facts, Judge West ultimately follows the plea deal, but not without reinforcing accountability. The sentence includes a probated jail term, parenting classes in lieu of community service, mandatory sobriety meetings, license suspension, treatment evaluations, monitoring devices, and employment verification. When it becomes clear the defendant does not own a vehicle, the judge adapts the conditions, ordering an affidavit of non-driving and continued monitoring to ensure compliance. This decision matters because it illustrates the court's balancing act, honoring negotiated pleas while imposing safeguards aimed at preventing future harm. The sentence is not lenient, nor is it purely punitive. Instead, it is structured to force behavioral change, protect children, and underscore that parental responsibility does not pause for personal hardship. The legal stakes were high, and the outcome serves as a clear warning. When children are placed at risk, the court's patience is limited, and accountability is unavoidable.